Article 125. Delay in the delivery of detained person to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal grounds and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties or their equivalent, 18 hours for crimes or offenses punishable by correctional penalties or their equivalent, and 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed, upon his request, to communicate and confer at any time with his attorney or counsel. Number 1. What are the elements of Article 125? Elements. Number 1. That the offender is a public officer or employee. Na ang may sala ay isang opisyal publiko o empleyado. Number 2. That he has detained a person for some legal grounds. Na ikunulong niya ang isang tao sa legal na dahilan. Number 3. That he fails to deliver such person to the proper judicial authority within A. 12 hours for crimes or offenses punishable by light penalties or their equivalent. B. 18 hours for crimes or offenses punishable by correctional penalties or their equivalent. C. 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. Nabigo niyang maihabla sa korte ang tao sa loob ng A. 12 oras para sa krimen na may parusang light penalties sa mga katumbas nito. B. 18 oras para sa krimen na may parusang correctional penalties sa mga katumbas nito. C. 36 oras para sa krimen na may parusang afflictive o capital penalties sa mga katumbas nito. Number 2. What is the crime committed if the offender is a private person? If the offender is a private person, the crime is illegal detention. Kung ang may sala ay isang pribadong tao, ang krimen ay illegal detention. 3. What does the phrase shall detain any person from some legal grounds mean? The Article 125, the public officer or employee has detained the offended party from some legal ground. The detention is legal in the beginning because the person detained was arrested under any of the circumstances where arrest without warrant is authorized. By law, the detention becomes illegal after a certain period of time because the offended party is not delivered to the proper judicial authority within the period of Article 125. Sa ilalim ng Article 125, ang opisyal publiko o empleyado na nagkulong ng naagrabyadong tao sa legal na kadahilanan. Ang pagkulong ay legal sa simula dahil ang tao ay kinulong ay hinuli sa ilalim ng alinman sa mga pangyayari at kung saan ang paghuli na walang warrant ay pinahihintulutan ng batas, ang pagkulong ay magiging illegal pagkatapos ng ilang oras dahil ang naagrabyadong tao ay hindi nasampahan ng kaso sa loob ng panahon na itinakda ng Article 125. Number 4. Does Article 125 apply when the arrest is by virtue of a warrant of arrest? Article 125 apply when the arrest made without a warrant of arrest but the arrest must be lawful. Mag-apply lamang ang Article 125 kung ang paghuli ay ginawa na walang mandato de aresto pero ang paghuli ay dapat naaayon sa batas. If the arrest is made with a warrant of arrest, the person arrested can be detained indefinitely until his case is decided by the court or the post a bail for his temporary release. Kung saan paghuli ay ginawa na may mandato de aresto, ang taong nahuli ay pwedeng makulong sa hindi tiyak na hanggang ang kanyang kaso ay magpapasyahan ng korte o di kaya siya ay magbayad ng bail para sa kanyang pansamantalang laya. The reason for this is that there is already a complaint information filed against him with the court which issued the order of warrant of arrest, and it is not necessary to deliver the person thus arrested to the court. Ang rason nito ay meron ng demanda na naisampa laban sa kanya sa korte na naglabas ng mandato de aresto at hindi kinakailangan na masampahan pa siya ng kaso sa korte. Number 5. What is the disposition of a person arrested without a warrant? In case falling under paragraph A and B of Section 5, Rule 113, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail, and he shall be proceeded against in accordance with Rule 112, Section 7, Section 5, Rule 113, Revised Rules of Criminal Procedure. Kung ang isang tao ay legal na nahuli na walang mandato kaugnay ng isang krimen na nangangailangan ng preliminary investigation, ang reklamo ay pwedeng isampa sa pamamagitan ng prosecutor na walang kailangan ng gayong investigasyon pero dapat may inquest na ginawa batay sa umiiral na rules. Kung walang prosecutor na magsasagawa ng inquest, ang reklamo ay pwedeng isampa sa pamamagitan ng naagrabyadong tao o alagad ng batas direkta sa akmang korte base sa affidavit na naagrabyadong tao sa humuhuling opisyal na tao. What is the meaning of the phrase, shall fail to deliver such a person to the proper judicial authorities? It will be noted that what constitutes a violation of Article 125 is the failure to deliver the person arrested to the proper judicial authorities within the period specified therein. Ating matatandaan na ang paglabag sa Article 125 ay ang bigong pagsampa ng kaso sa akmang korte sa loob ng oras na isinaad nito. Number 7, when do we say that the duty of detaining officer is deemed complied with? The duty of detaining officer is deemed complied with upon the filing of the complaint with the judicial authority. Ang tungkulin ng nagkulong na alagad ng batas ay masasabing natupad na sa pamamagitan ng pagsampa ng reklamo sa korte. Number 8. What is the meaning of phrase proper judicial authorities? The term judicial authorities as used in Article 125 means that the court of justice or judges of the said court vested with judicial power to order the temporary detention or confinement of a person charged with having committed a public offense. That is the Supreme Court and such inferior courts as may be established by law. Section 1, Article 8 of the 1987 Constitution. Ang terminong judicial authorities na ginamit sa Article 125 ay nangangahulugan ng korte ng hustisya o mga huwes na nabanggit ng mga korte na pinagkalooban ng kapangyarihan na nauukol sa korte na naguutas ng pansamantalang pagkakakulong ng tao na pinaratangan ng pagkakagawa ng krimen. Iyan ay ang Korte Suprema at ang mga korte na nasa ilalim nito. Number 9, what if the judge is not available? What should be done with the detained person? When the judge is not available, the arresting officer is duty-bound to release a detained person. If the maximum hours for detention provided under Article 125 of the Revised Penal Code has already expired, failure to cause the release may result in an offense under Article 125. Kung walang huwes, ang humuhuling alagad ng batas ay may tungkuling palayain ang nakakulong na tao. Kung ang pinakamataas na oras para sa pagkakulong ayon sa Article 125 ng Revised Penal Code ay natapos na, bigong mapalaya ang tao, magriresulta sa isang krimen sa ilalim ng Article 125. Number 10. What is the procedure to follow if the arrested person by virtue of arrest without warrant asks for a preliminary investigation? Before the complaint of information is filed, the person arrested may ask for a preliminary investigation in accordance with the rule. But he must sign a waiver of provision of Article 125 of the Revised Penal Code as amended in the presence of his counsel, notwithstanding the waiver. He may apply for bail and the investigation must be terminated within 15 days from its inception. according to Section 7, Paragraph 2, Rule 112, Revised Rule of Criminal Procedure. Bago ang reklamo ay isampa, ang hinuling tao ay pwedeng humingi ng preliminary investigation alinsunod sa rule. Pero kailangan niyang pumirma ng waiver sa provision ng Article 125 ng Revised Penal Code as amended sa presensya ng kanyang abogado. Kahit na may waiver na, pwede pa rin siyang mag-apply ng bail at ang investigasyon ay kailangang matapos sa loob ng 15 araw mula noong sinimulan ito. According sa Section 7, Paragraph 2, Rule 112, Revised Rules of Criminal Procedures.